So I want to do one final takedown of committee substitute for Senate Bill 1890. It's important we understand exactly what version is in front of the legislature right now. It's the C2 version of it. But an overarching concern, no matter what version that we're looking at, is the problem that our legislators don't seem to be responding to the interests of the general public. And I think that's reflected in the legislation that sits before us now. There's widespread understanding that the foreclosure process that chokes this state right now is permeated by fraud and abuse by the banks and institutions. And the larger concern is that while we see a lot of interest focused on this particular bill here and a lot of interest on other policy matters, especially in this state and frankly in other states across the country, you see no concern whatsoever for the issues that caused all of the problems that now choke our court system. Now, what I'm talking about is the fact that, according to some estimates, there's 368,000 foreclosure cases that are pending in our courtrooms. Now, I was proud and very pleased to hear some senators in last Monday's debate raise the issue that they are concerned about flawed and fraudulent documents that choke our court system. But unfortunately, over on the House side, there's no concern whatsoever for it. And in sort of a bigger picture, you see no legislation at all which seeks to address the important issues related to fraud that frankly are causing a very real crisis in confidence in our entire system of governance and especially our court system. When the general public is as aware as the general public is today of the fraud, of the abuses, of the overreaching by the banks and institutions, and yet they see their elected officials doing absolutely nothing to punish, much less even respond to those abuses, it causes a very real crisis in confidence in our system of government. Quite simply, how can the people who are governed have any respect for the authority of their government when day after day, week after week, they are treated to examples of gross abuses that are being perpetrated on them by the banks and institutions? The banks and institutions, by the way, who are surviving now and frankly thriving as a direct result of the taxpayer subsidies that they receive on a regular basis, beginning in 2008 and continuing even today. So again, the larger issue that permeates and transcends this particular piece of legislation is the fact that our government is entirely unresponsive to the concerns of the voting population, and in the long run, that's going to cause quite a bit of blowback. It's starting to come now, and it's frankly only going to get worse. But turning particularly to the piece of legislation, I think it's so important that we actually be looking at the text of what's in front of our elected officials, particularly when you're making calls to these elected officials. And frankly, I think it's critical, obviously, that our elected officials know exactly what it is that's before them. So I'm going to do a takedown of this, and I'm going to focus specifically on the bill itself. It's broken into a couple different parts. The introductory part seeks to make some technical changes to the existing pleading standards in law, and in my estimation, these are very messy, and the changes that are made in here are not going to make things more clear. They're in fact going to make things a lot more difficult and muddy, and will have an impact on some appellate cases. So that would be the first section. The second section I would call the order to show cause section, and this really is the cornerstone of the legislation at this point in time. The assertions made by the proponents is that this particular section will allow lien holders, and particularly the condominium and homeowners associations, the ability to move foreclosure cases faster. That begins at around section 157, and I can just tell you that's just absolutely not the case at all, for reasons that I'll get to in just a second. And then finally, the last section dealing with abandoned and vacant property, and the assertion that this section here will allow banks and institutions to speed up foreclosure processes on vacant and abandoned property. And the fact of the matter is that that's just not the case at all. And so that itself is an untruth about the legislation. So looking at it and beginning in section 3 around lines 73 and 74, we see the proposed point of this bill in this section is to make the requirements more clear of pleading standards. The fact of the matter is that our existing rules of procedure and case law already make it abundantly clear what the rules are and what the pleading requirements are when a foreclosure case is filed. it's not necessary to put this additional language in there, which is frankly going to conflict with the rules of civil procedure and cause some conflict among the case law that's already out there in some of the cases that are pending in appellate case. Line 82, it says this section is not intended to modify existing law regarding standing or real parties in interest, and in fact it does. That's part of the problem. Getting into line 92 and going down to line 104, there are technical words here that are being blended and thrown around, and they're frankly going to make things much more confusing. I'm dealing specifically with the word holder. Now, there is a debate among the appellate courts right now, and it's a debate that's flying among the trial courts regarding the specific legal word holder and owner. It should be noted that the existing case law and the existing rules of procedure require plaintiffs to plead owner, and in this case, we're substituting that with holder, and I suspect that's a backdoor way of trying to resolve some of the problems that exist in our trial court, but that's a very important word that's just being glossed over here. Importantly, and this is a huge glaring error, we're talking about a bill that is purporting to address issues of mortgage foreclosure, and the fact of the matter is that in this new pleading section, it completely eliminates the mortgage from the requirements of documents that need to be filed. This is an example of where this conflict will set up trial and appellate problems, because it is clear that under existing law you have to file the mortgage in order to file a mortgage foreclosure complaint. Well, somehow when whomever was drafting this, they just left out the mortgage and assignments entirely and are only talking about note. That's absolutely improper, and it conflicts with the existing law. At section 132, it asserts that the court can sanction a plaintiff for not complying with the rule, but the fact of the matter is a court already can. So that language in there, 132 to 135, is superfluous and frankly it's just a mess. Getting down into line 142, the existing language was pretty clear. The court's ability to set a deficiency degree was in sound discretion. This language that's there is just clunky and doesn't work. You have to actually read it and see that the pieces don't fit together, and the language is just a mess and is going to cause confusions. Getting into section 5 at line 57 and 159, this is perhaps the messiest part of this entire provision. It asserts that any lien holder can start the show clause proceedings, and that's just frankly grossly improper. There are all sorts of nightmare scenarios you can envision when a $50 lien holder initiates a foreclosure process, and because of this language in here, they're able to set a foreclosure process and set in motion the order to show cause proceeding. That's just absolutely not contemplated by our existing law or existing lien theory. Arguably, when you give a mortgage or you're part of a condo association, maybe that procedure in the order to show cause proceedings are appropriate, but it's just grossly improper to assert that any old lien holder can engage in that proceeding. But again, what they suggest with this order to show cause proceedings is that condo associations or homeowners associations can use this order to show cause proceeding in order to speed along foreclosures, and that's just absolutely not true. This section could force a court to have a show cause proceeding, but there is absolutely nothing within this law which would allow a homeowners association or condo association to force a sale if the bank who has the first mortgage does not want them to. An important point, and this is at line 190. Much of the objection to the show cause proceeding is this thing has to go through. Much of the objection could be solved by changing the word may constitute at line 192 to shall constitute. It would say that the filing of defenses or pleadings by a defendant shall constitute cause for the court not to enter a final judgment. If that one word were changed, it would be a big help in making this not so objectionable. But I've heard some discussion about the fact that according to new legislative drafting standards, the word may doesn't really mean may, it doesn't mean shall, but that's a whole nother issue. Moving on into the other objectionable sections of it. Have to do with the contested proceedings, and if someone comes to court, what's the standard for whether or not they have the ability to raise defenses? That's for a judge to determine, and not in this case in this legislative language. another part about the requirements beginning in line 352 that a lien holder in this order to show cause proceeding, a court shall force a defendant to make plaintiff payments on the mortgage. Again, because of this messy language of allowing a lien holder to start the proceedings, you could have a $50 lien holder starting these proceedings and then forcing a homeowner to make mortgage payments to a mortgage holder if it's there. It's just ugly and it's messy. And moreover, as that language continues down at line 372, the court ordering the homeowner to make payments on a mortgage at the direction of a lien holder, and then if that homeowner doesn't make those payments, down at line 372, the court has to order possession of the property to be turned over to a plaintiff. It's just messy. It doesn't work the way they assert that it does. Moving then into the vacant property provision, beginning at line 403. The fact of the matter is that this is part of the big lie of this proposal and this bill. If a plaintiff wants to conclude a foreclosure proceeding, the existing case law and rules will allow them to do it in roughly the same amount of time they always have, 4 or 5 months or so. The lie that we hear constantly repeated is that it takes 600 days or whatever to conclude a foreclosure, and that's just not true. But with regard to this assertion that we've got a problem with vacant or abandoned properties, yes, we do have a problem with vacant or abandoned properties, but it's not within our existing laws. If the plaintiffs want to avail themselves of the existing law, all they have to do is certify that they cannot locate a defendant. They publish against them, and they're able to get possession of the property in a very short period of time, 3 months, 4 months max. The problem is the plaintiffs are not using the existing law. So to go in and change our law because the plaintiffs, for whatever reason, aren't utilizing the laws as they exist is grossly improper. Now, the other part of this bill is that it sets up requirements for the courts under this expedited proceeding to issue subpoenas and review information filed by power companies. And so in a time where our judicial system is grossly underfunded, our judges are under more pressure than ever before, this legislation puts additional pressures upon them, which frankly we should not be placing upon our judicial branch, because quite frankly the problems that exist are not because our laws don't work or not because our court system isn't functioning properly. It's because the plaintiffs are not doing their job properly. And again, it's the failure to recognize the wrongdoers in this situation, the banks and institutions, that the voting public and consumers across the state of Florida are responding to. It's frustrating that the press picks up on this legislation and all you read are the headlines saying that this is going to make things faster, better, or whatever, but the press isn't actually analyzing it and looking at the legislation. And frankly, it's even more frustrating that our legislators are just asserting that somehow this is going to do something to support or address the foreclosure problem without actually reading the legislation and pointing to specific sections in there that support that proposition. It's just not. I'm encouraged by the work that the senators are doing and in recognizing the problems with this legislation. This is bad for Floridians. It's bad for foreclosures. We need to focus on jobs and solving the problems within our existing laws, not junking up our statute books with additional laws that are just going to be more messy in the end.